Good morning, Pete. Good morning, Tim. Again, as I just said, but I'm going to say it again because now we're recording. This is Financial and Estate Literacy. It's Your Estate, Fall 2023. We're doing retirement planning. And what I'm going to do is bring back up my screen and do, why did it go away on me? Share screen and get you this. And incidentally, as before, if I look this way, it's because I have a laptop over there that's logged in just like a normal participant would be to see what was going on. So here's what we're doing. And then I want to do this. There. In the material, and we'll show you this. Huh? Oh, that's probably Pete on the phone again. Pete historically at 10 o'clock receives a phone call. It's one of those things where you have yourself paged in the hotel. That's Pete. 10 o'clock, Pete gets message. Anyway, this there's a workbook that we had done years ago, and you're welcome to download it. There's the site down here at the bottom. It's the same one that you have had as a reference in terms of getting other material. The other thing that is a bit different this time is I wrote a couple of little booklets that are like 20, 30 pages, something like that. One on estate planning, one on charitable giving, one on financial planning. You're very welcome to download those and take a look at them. As a reference, incidentally, sort of jumping to the end of today's discussion, next week we are not here. It will be an off week. There will be no notification, no anything else along with that, but that's what will be done next week in terms of where we are. I'm going to switch sharing and go here because we want to touch briefly on this. Let me bring this guy to
Tim, did you send in your
yes, it's there.
outline?
I have it up.
Okay.
So it's there. We'll look at it right now, Pete, to make sure that it's there. So
sounds good.
This is the website. The easiest way to get here is IYME. It's yourmoneyestate.org, not com, org, and it will bring you into here. When you come into here, if you click on workshops and it's your estate, thinking. Then we're going to scroll down here to retirement asset planning. Incidentally, the videos are here. I'm sorry.
You're going to click on that?
I just did, Pete. Don't we just love having live demos? Okay. Click. Don't we love live demos? Okay.
Yeah.
Are we already here? No, we're not.
No.
So it's not letting me do this at the moment. So if I go here, yes, there you go. We woke up.
There you go.
Okay, so if you scroll, incidentally, the estate planning workbook that we had in there, and then the 3 booklets that I did, and a blank ask first form that we may touch a bit on. Then if you go down to Zoom videos, there's today's handout material, and also the ask first form for Tim. So all the material is here, and Pete will want me to do this, so I might as well scroll on down. So at the bottom, you will see the various articles that we have. Do you want to comment on any one in particular, Pete?
No, it's just all about the IRS and the Secure Act. One of the session today is going to have a lot of vocabulary. And so it's a pretty complex area, lots of changes. And there's some articles that that are right on point. Just to give you just a little bit of background on financial and estate literacy, we're a volunteer program. Our mission is to educate you on money, financial, charitable, and estate planning. So that's our purpose. No one is going to call you. No one is going to sell you a product. All of our presenters are volunteers. Don is our board member and also our philanthropic advisor. He's going to be doing the charitable planning session. And the whole idea is that you don't have to pay Tim's hourly rate to get educated on the estate planning. He's doing this at gratis, and just one of attorney's favorite words is depends. So we'll see how many.
The older you get, that can have multiple meanings. So at the moment, we're going to talk about it depends on the situation.
Yeah,
that's all we're doing now. since
So
next week is my 74th birthday.
we're going to
just
count how
about.
many times he has to say the word depends throughout
Yes.
the word
Yes.
throughout the presentation today.
So what I'm going to do is I'm going to be monitoring the Q&A, and I'm going to turn off my video microphone, and I'm going to interject along the way. Tim and I already discussed that. And so I will be the voice of God in the background and ask questions as we go. So
Okay.
Tag, you guys are it?
Okay. Well, we're going to do a quick introduction of you, Tim. Can you pull up your Ask First form?
Yes.
In the meantime,
There it is.
there it is. Master's or other advanced degree, Stanford University, law degree from Pepperdine.
Yes.
How long have you practiced in the estate planning area?
Since finishing law school, so more than 20 years, I've been working in law firms. I worked at Pacific Life Insurance Company for a while, but it's always been, I've always had my estate planning hat on.
Yeah, that's the kind of person that you want. Great educational background. Let's go right down to how you charge your clients. So what does a flat fee mean? And give us an example of that.
So as best I can, for when I prepare estate planning documents for clients, living trust, will, power of attorney, healthcare directive, kind of those documents. If someone has documents that were done 10 years ago or 5 years ago, or they want to be reviewed, or if someone doesn't have new documents, it's, hey, let's have a meeting for an hour. Let's talk about what you want, what you need, what your goals are. And then at the end of that, at the end of that discussion, I have a pretty good idea. If you've given me enough information, I have a good idea of what the charge is going to be for estate planning documents. So those types of situations, I just charge a flat fee. So you know exactly what you're going to pay for your basic estate planning documents.
Give us an example.
For a single person, somewhere around $3,000. For a married couple, somewhere around $4,000. It really depends on the situation. The first depends.
The first depends.
Yeah, I mean, I had a client once that was worth close to $10 million, and literally it was all in an IRA. So all, very, very, very basic documents she needed.
Yeah.
Very basic will, power of attorney, healthcare directive. Conversely, I've had clients that are worth $2 million, but they own 15 different pieces of property out in Adelanto and Hesperia.
Or have to give their to 15 different organizations. Or
exactly. So it's like there's not a lot of money there, but there was a lot of work just because there's a lot of assets, a lot of moving parts. So again, that's why I say it depends, just because I never know what I'm getting into. But for the most part, I'd say 80-90% of the time, a single person around 3,000, a married couple around 4,000.
What is your hourly rate?
So when it comes to like a trust administration, so someone's passed away and now I'm going to be involved in representing the trustee and contacting beneficiaries, making sure assets are sold and distributed to various beneficiaries. For those types of hourly engagements, it's $4.95 an hour.
$4.95 an hour. And then on your first consult, is that a charge to the client?
The initial consultation, no charge.
No charge. So somebody could come in, make an appointment with you and sit with you. And then after that appointment, you would give them as to what you would charge for doing their estate plan.
Exactly.
You don't team up or you sell annuities, insurance, or mutual funds on the side?
I don't sell any types of financial products. I don't sell anything, in fact. I just sell my legal services. That's it.
Yes. And where are you located? Why don't you scroll down just a little bit more so they know where you are?
Oops. So my office is in Fashion Island, and I'm usually I'm in the office between the hours of 8:30 and 4 Monday to Friday. But again, I sometimes earlier, sometimes later, just depends on the situation. But I do physically come to the office most every day.
And you like emails?
Emails are great.
Yes.
Probably the best way to get a hold of me is an email.
Yeah, because you can respond to them at night. Okay.
Yes.
Let's get into the program, and you are ready to get going. You know, in the estate planning area, when we're talking about doing a will, a durable power of attorney, an advanced healthcare directive, and a living trust, a lot of attorneys don't pay much attention to the retirement assets. And so one of the things that you need to ask your attorney is that not just have them hand you a letter and say, okay, take it to your bank and brokerage statement. You need to know a little bit more about it. And because there's a lot of issues going on. So you got the outline up. So what are individual retirement accounts and why should they be important?
Yeah, so the retirement accounts are, as Pete mentioned, an often overlooked item as part of your estate plan because you've met with an attorney and you've got a little bit of education knowing, hey, I need a living trust to make sure I avoid probate. That's very important. I don't want to have my assets subject to this overly complex, expensive, time-consuming process. So you make sure your assets are part of the trust, be it bank accounts or real property, business interests. But IRAs, being retirement accounts, there are special types of assets. And IRAs are individual retirement accounts. And sometimes when I use the term IRA, I kind of mean all different types of retirement accounts. There's IRAs, there's SEP IRAs, there's rollover IRAs, there's Roth IRAs. But in this world, I'm talking about retirement accounts such that the purpose of IRAs were, IRS has the General Revenue Code has provisions about helping people save for retirement. So very basic, an IRA, you set it up, the person who put the money in, you're the owner of the IRA. And when you contribute money to that IRA, you get an income tax deduction based on the money you can put into the IRA. Then while the IRA is in effect, the money in that IRA grows and grows and grows, tax deferred. You don't pay any tax as that money is invested and growing. But then at some point, when you pull the money out, there will be an income tax event at that point, and whatever you pull out of that IRA is just subject to ordinary income tax.
Yeah, it's no longer, it used to be, the estate planning area, we used to be concerned about the estate and gift tax area. We did AB trust and we did all sorts of things to try to minimize the estate tax. Well, today, people have an income tax estate. And that is if you own an annuity, if you own a 401k, a 403b, an IRA account. There's what is the term that, there you go. We're going to get to it just a little bit.
But Tim, I want you to scroll back up for a minute because I want to emphasize something you emphasized. You have encouraged individuals to save for retirement because an IRA is owned by a person. And that is very important when there's inheritance of this. Does it go into the trust? Well, a trust is not a person. And so individuals, that's one of the things that drives a lot of the things that affect this account is it needs to be an individual. There are exceptions. It depends. But on the other, basically it is, I'm making notes on how many, but to the IRS, an individual owns an account.
Yeah.
So,
yeah.
Okay, now you can go on the other ones.
Thank you, Don.
Yep.
All right. So, and how does that get taxed to the individual?
So again, here I am. I've decided to contribute money to my IRA. Whatever I put into that IRA, I get an income tax deduction for. And then at some point later, when I pull the money out, that's ordinary income tax. And the idea behind this is that, hey, I'm working now. I'm going to sock away this money. I'm going to let it grow. And so then at some point when I retire, when I'm not working anymore, I can use this IRA, pull the money out, pay income taxes on that, and that will help me pay for my, expenses after I'm no longer working on a daily basis.
Okay, let's think everybody understands the difference between a regular IRA and a Roth IRA, but briefly go through that.
So a A regular IRA, again, you put the money in, potentially get an income tax deduction, and pull the money out, ordinary income. When I say potentially get an income tax deduction, you can see on my outline that there are a lot of rules about how much money you can make and whether or not you're, if you're employed, whether or not your employer provides some type of a employer provided retirement plan, about whether or not you can make contributions to an IRA that will be, you're able to deduct from income taxes what you put in.
Yeah.
Roth IRAs are probably, 25 years old now. The great thing about Roth IRAs is you put the money into the Roth IRA. There's no immediate income tax deduction. However, while the money's in the Roth IRA, it's growing tax-free. So at some point, when you do retire, you pull that money out, you don't pay the tax on it. It really is kind of the, if you have a long-term horizon for retirement, it really is the ideal vehicle because you're socking money away in a certain account. And of course, there's limitations on how much you can put in there, but you allow that money can grow and grow and grow. And then at some point, when you are retired, you pull the money out, you're not even paying any tax then. So it's a huge, powerful tool. And it surprises me that Congress has let it go on as long as it has, because it's a total boondoggle.
Yeah, but let's assume for this particular presentation that most of our audience members are retired. And so they're no longer contributing to their regular IRA, but they're trying to figure out, as to when do they have to take withdrawals.
So getting down to point 3 of some of these tax consequences of drawing from a retirement account.
We're going to skip around your outline a little bit, but so bear with me.
No problem at all. It's a good question. So the bottom line is, if you're under the age of 59 and a half and you tap your IRA, you want to take a distribution of it, problems arise, and that they'll make you pay a penalty for taking the money out of the IRA because you're not over the age of 59 and a half. But if you're over at the age of 59 and a half, then you can take money out of the IRA, ordinary income tax, no problem. Then at some point, there's this required minimum distribution.
I'm going to back you up to the under 59 part. If I'm under 59, I have to pay a 10% penalty to the feds and a 2.5% penalty to the state, plus ordinary income tax.
Right. It's the penalty plus ordinary income tax.
Right. So it's
a pretty
top
stiff
of your
penalty.
ordinary income tax, you get hit with 12.5%. Right.
Right.
But if you need it, you need it, but be aware of what that's going to cost you.
Yeah, it's not something that is shouldn't be the first place. If you're looking for cash, that shouldn't be the first place you go to drain your IRA when you're not 59 and a half. But if you're over the age of 59, then you can take money out of the IRA, still pay ordinary income tax, but there'll be no penalty for taking money out of it. Again, 59 and a half, that's the limit, the threshold, that anything after that point, you can access your IRA without penalty. But then with this required minimum distribution, when you reach a certain age, the government's not going to allow you just to keep all the money in there forever and ever and ever as it continues to grow tax deferred. When you reach age 73, that's when you are forced to take a required minimum distribution, this RMD.
Yeah.
Yes. And so at that point, then, even if you don't want the money from the IRA because you've got other assets, the IRS says, look, you got to take money out of this IRA, this minimum amount every year, because at some point the government wants to tax what's been sitting in this account for so long, growing tax deferred.
Yeah, and people should really look at that IRS publication 590B because the rules have changed for this particular year. So you want to make sure that's updated. And the IRS is serious. If you don't do it, you've got a penalty to pay.
25% penalty for not taking an RMD. That's even steeper than taking an early distribution penalty. So
yeah. And just as an example, and Tim and I were talking about this before, I use an 80-year-old as an example. If I'm 80 years old, I have a factor of 20.2. What you do, and Tim, I'm jumping ahead on you slightly, at the end of the year, so December 31 of last year, here's how much money I have. And you divide that by 20.2 if you were 80 years old. And then you pay the net. So as an example, if you had 500,000 in your account, to make the number round, if I divide by 20.2, I have an RMD requirement of $24,752. Somehow you're going to wind up taking out that money. It varies by year. One, the balance of whatever your account is. The other part of it is that rate changes. So for 80 is the factor is 20.2. It changes each year as you age along the way. And as a simple, maybe a simple way of looking at this, for instance, I have an account at Schwab. And so on my Schwab statement or on my wife's Merrill Lynch statement, if you go to almost the back page, it's like just above the disclaimers, there's this little section in there that says your RMD for, in my case, it told me last year how much I took out, this year how much I will have to take out. So if the math bothers you, or you don't want to go find out what the percentages are, you can go to those statements. Some smaller brokerage firms don't do that, but most of the majors will do that somewhere on the document. You might have, I had to hunt for it for a while, and in both of ours, they happen to be near the end of the statement. But month over month, it'll tell you, here's what you should have taken last year and you did, and what you need to take this year before December 31.
Tim, do you,
Yes.
if you have multiple IRA accounts, do you have to take it out, each RMD out of each individual account, or can you just take it out of one of your retirement accounts?
That's a good question. And if you have multiple IRAs, you can satisfy your RMD by taking it all out of just one account.
Okay.
But
And-
that being said, if you have multiple IRAs, it's hard to determine, your minimum distribution on each account. And then you can take all of, add all of those numbers and take it from one. So typically people, as part of like, hey, I've retired and I'm trying to get my financial house in order, my estate planning documents in order. This is usually a time to say, hey, I don't need 4 IRAs anymore. Maybe when I was working and I was, contributing to all these different IRAs, there was a purpose for it. But now that I'm retired, make your life easier. Consolidate to 1 or 2, just so it's easier. How much to take out as a minimum distribution.
So you could draw down the smaller one and basically effectively close out that account by using a combined RMD requirement across your 4 accounts. My sister wound up, for some bizarre reason, with multiple IRAs, and I keep going, consolidate them. Why are you? And she does each one of them individually. No, put them all together and close out the little ones. Yeah.
It just makes your life a little bit easier. But I know that having different jobs in the past, sometimes I leave a job, and this is getting back to my point number 2 of 401k, 40357s, also retirement accounts, but they're employer provided accounts. So one of the benefits of working for a company would be, hey, we're going to allow you to join our retirement account, and we will have some sort of benefits here that it says I can put more money in this employer provided retirement account. The employer provides the structure and the framework for it, then the money that I can put into just an individual retirement account. So, but having several jobs in the past, I have a 401k at X job, and I go to a different job, and I forget about that 401k, and I entered my 401k with a new job or whatever. But every once in a while I have to look back and say, why am I getting 4 different statements from all these different stuff? I just consolidate all the stuff now. There doesn't make any sense to keep different money in different pots everywhere. Just put it all in one spot just to make it easier for yourself, just to financially simplify your life.
We're not going to get, we haven't gotten to at death yet, but keep it on the 401k and the 403b. Should somebody, if they have a 401k, 403b, or a 457 plan, should they roll that over once they retired from their employer to a rollover IRA? What is your suggestion? And I know it depends.
I wasn't even going to say that because I'm going to call me out. But that's a question best for your financial advisor. As a general rule, though, when you have a company provided 401k, 403b, 457, you are able to put a lot of money away in those retirement accounts, but then you're limited to the investment options. Like I remember working at Pacific Life Insurance Company, and there was essentially like 9 mutual funds that you could choose from to invest your money. That was it. So, and those are, some of the mutual funds were okay, but some of them I didn't think they were all that great. They didn't have great returns.
Yeah.
So as soon as I left that company, I immediately moved that money from the 401k over to a rollover IRA. And then, since it's a rollover IRA at Schwab, Fidelity, Vanguard, I can now invest in the universe, anything I want to, not just the 4 or 5 or the dozen funds that the company says you should invest in these.
Yeah. And it also, from an estate planning point of view, a 401k is an employer driven plan. And so therefore you may not, well, we'll get into a little bit later, you may not be able to do a stretch. You may not, you're much more limited. Is there any disadvantages from rolling it over to an IRA from a legal point of view?
I guess you could, there are, the one potential disadvantage is when it's in a 401k or this qualified plans, 401k, 457, 43B, there's probably going to be some more asset protection features to those plans than in just a traditional IRA plan.
Yeah.
But in my mind, you have to, there are a lot of people that worry about asset protection, but I ask them, well, why are you worried? And it's like, it's because someone scared them into worrying about it. Where typically most people don't have high profile jobs or in businesses that they're going to get sued commonly or whatever. So it's like, yes, there might be some asset protection features from those types of qualified plans, but in my mind, the chances of you getting sued and having some big lawsuit or whatever and trying to protect assets from a lawsuit, that the chance of that happening is very, very low, versus I know what's going to happen is that most likely you'll never have a problem, and it'll be a lot easier for you to pass that money on to beneficiaries when it's in some type of a rollover IRA than your employer provided retirement plan, the qualified plan, just because the employer just wants employees investing in it. They don't want retired employees. They don't want former employees there. So they don't give you a lot of flexibility.
So the general rule is look at doing a rollover IRA, and it gives you more options as far as investments are concerned, and also gives you more options as far as beneficiaries are concerned.
Yes.
I'm trying to think of other issues during a lifetime that let me say, we touched on it briefly, but some people like to, what are the rules in turning a regular IRA to a Roth IRA?
So
And
go ahead. I'm sorry.
No, go ahead. And what are those rules? And when should somebody consider doing something like that?
Again, that's a great conversation to have with your financial advisor. That's not something that I get involved with. But yes, you can convert your IRA into a Roth IRA. Obviously, though, when you do that, you're going to have to pay income taxes because the money you put into the IRA, you got a deduction for. So when now you're putting it into a Roth IRA, now you got to pay those income taxes associated with, you had $50,000 in an IRA and you want to convert it to a Roth IRA. Well, now you're going to pay $50,000 in income tax that year because you're moving it into, if you put the money into the Roth IRA to begin with, that was after-tax money. So you've got to make the IRA money after-tax money so you pay tax on it. But again, if you have a long retirement horizon, then that's a good deal because that $50,000 is going to grow enormously and it will all be free from income tax when you pull it out.
So there's no general rule. So you need to see a CPA or a financial advisor to run the numbers to see if it makes sense to you. And one of the key ingredients, if it makes sense, is that you're going to hold it in the Roth IRA for a long period of time.
Yes.
So I'm trying to think of any other issues that during lifetime. Oh, let's say you have during a lifetime, you're married and each spouse has an IRA account. One of the spouses has a heart attack or a stroke. They're still alive, but can't function as far as handling their own financial resources. And the spouse that's still healthy needs to make some changes in the IRA account. Can they just call up Schwab or Fidelity or Vanguard and say, hey, my husband had a stroke and I need to get some monies out of his IRA? Will they listen to her?
Unfortunately, no. The spouse and the wife in that situation can't call up Vanguard, Fidelity, wherever husband has his IRA, just because it's the husband's IRA in his name alone. The wife might be the primary beneficiary, but she's not the beneficiary so long as husband's alive. He's still alive, therefore he's the beneficiary. So in that situation, it's extremely important. And I think you talked about this earlier in the session, a durable power of attorney. Husband needs to have a durable power of attorney, make it very clear that if there are any assets in his name alone, that if he's incapacitated, now wife can run to Fidelity, Schwab, Vanguard, whatever, with a copy of that durable power of attorney and possibly a letter from a doctor saying husband's incapacitated. And then, yes, the financial institution would listen to the wife to make changes to that IRA or pull money out of the IRA, because now she's acting as an agent on his behalf because of this valid power of attorney that was drafted long before husband became incapacitated.
So during their lifetime, husband and wife should go to the Fidelity or Schwab or Vanguard or wherever they have that brokerage IRA account or the bank, and make sure that they have the durable power of attorney on file.
It would be helpful, yes. And sometimes these financial institutions, they will accept an attorney drafted power of attorney, but a lot of times I find that these banks want their own form power of attorney. They're on something that they produced on file, so they know exactly what's going on. And so, great, let's fill out a new, Fidelity power of attorney form, so it's very clear that if spouse is incapacitated, then the other spouse can act on his or her behalf.
So don't fight City Hall. Go ahead and complete their power of attorney, and because now you have legal authority in the event of an incapacity issue.
Yes.
Don, you have a question?
Yes. So we talked a little bit about asset protection being perhaps stronger in a 401k or other kinds of things. Does that asset protection extend to a beneficiary?
The answer to that is no.
Let me make a note on another depends.
No, he didn't say depends. He said no.
There's no.
Oh.
If it's your IRA, then there's some asset protection. But if you die and now that 401k is now going to your named beneficiaries, the asset protection that you had no longer rolls over to that beneficiary, because it's not the beneficiary's money. It was your money.
Right. And I'm going to guess that the 401k the company's going to say, you're not inheriting the 401k, you got to get it out of here and convert it. Would be the other part of that one. I'm going to ask you, there's another question, and while it's off track of where we are now, I want to go ahead and raise it at this point. Is it ever beneficiary for a married couple to have their own trust, or should they always have a joint trust? We are married late in life and hold most properties and assets separately. Second part of that question is, we also have a prenup. Is that affected by a trust?
Ooh. Wow. Do you want him to answer these questions on no charge?
These are good questions. So yeah.
The answer is
yeah. So with the prenup, we have to review the terms of the prenup. And sometimes I see prenups say, we've completely opted out of community property. California being a community property state, if you're married, you're living here, everything's 50-50. My wife makes $1 million a year, I make $100,000 a year. It doesn't matter, it's all 50-50. But my wife and I could have had a prenup. We got an agreement before we got married that says, we're opting out of community property. Whatever she makes is hers, whatever I make is mine, the end. So it just depends on what the prenup says. So there's our first depends. But a lot of the prenups, it's either opting out of community property or, hey, I'm walking into this marriage, but these are my separate assets, and they're always going to be my separate assets. And the other spouse the same way. So in those types of situations, it's very common I have clients who, all right, you both have your own separate property. So
yours, mine, and ours.
I'm going to be the attorney for one of the clients, and then we'll find another estate planning attorney to be the attorney for the other client. And we can decide, each spouse can decide what they want to do with their separate property assets.
Yeah. Good.
Thank
Good.
you.
By the way, Tim.
And so And so getting down to like retirement accounts, it's like, well, it depends on what does your prenup say? I mean, if this is your separate property IRA that you had long before you got married, maybe you just want your kids or your named beneficiaries
Right.
to be the beneficiaries on that account. It doesn't have to be your spouse. You could
Right.
put your spouse, you could put down your kids or other, charities, other individuals, or you could put down a trust as the beneficiary too, but it probably depends on what trust you want to be. It's probably the trust that you created where you've got provisions that say, these are beneficiaries, these are, my spouse, my kids, the beneficiaries, what have you. So
Right.
it's a very involved question. And I just kind of would need more information to
Right.
help
Right.
decide what exactly the way to do is. But
Okay.
the bottom line is, who you name as a beneficiary on that IRA is completely up to the IRA owner. They can do whatever they want, but just realize that there are some beneficiaries that you just name as, if you name your kids, well, then they're totally in control. They can do whatever they want. Versus you can name your trust as the beneficiary, and then the trustee of the trust would then be managing that IRA account for the benefit of each of your kids or the beneficiaries.
We're going to
Thank
get into who do we leave as a beneficiary in just a little bit. I'm just trying. What happens during lifetime that individuals need to be concerned about, and that's going to lead me to another question. Is the IRA that you have community property if it was earned during marriage?
So technically the IRA is community property when it's earned during marriage. I've had clients divorce, and then they have to have a quadro, a qualified domestic order, basically severing an IRA. So it was an IRA in husband's name. He put every dime of that went in there was community property funds. Now there's a divorce. So now they're separating that IRA so that husband will have an IRA and wife will have an IRA.
Yeah. So it is although it's your individual name, it's still community property and needs to be split 50-50. And so if one spouse tried to give away that IRA to another person, Schwab or Vanguard, they may question as to, did you get your spouse's permission?
Yeah, a lot of times I see those beneficiary forms and they just assume, hey, it's your spouse is the primary beneficiary. And if your spouse is not the primary beneficiary, your spouse also has to sign the form.
Yes. Yes.
So they make it, you can't pull a fast one on your spouse. Oh, I'm just going to put my favorite charity down or my brother down. No. That won't be a valid beneficiary designation because you're married, you've got the IRA, and they'll say, if it's anyone but your spouse needs to sign off on that to be okay. That's going to go to someone else, not your spouse.
So during lifetime, you have a beneficiary designation form with all of the mergers and buyouts. And what happens if your beneficiary form is lost?
The bottom line is, if you had a First Interstate bank account 30 years ago, which became Wells Fargo, which became something else, whatever, it's like, you need to make sure.
Heard that name in a long time.
Security Pacific. I literally had a client at a Security Pacific IRA, which became B of A eventually, whatever, and he still had the Security Pacific beneficiary designation form. And I told him, humor me, go down to Bank of America and put a new form in place, because I doubt that B of A took all those forms.
Yeah, but let's say we can't find a form. What happens?
If there's no form and the company has no record of any beneficiary and you pass away, the default is the estate of deceased person. And now you've got a probatable asset.
Okay.
And I've had clients, for one reason or another, just forget to name beneficiaries. And so then there's a $200,000 IRA that's subject to probate because there's no beneficiary on it.
Yeah. So you might have a probate estate if your designated beneficiary form is lost. What do you usually recommend to people to make sure that they have an up-to-date beneficiary designation form. In your practice, do you ask them to bring their designation form into the office with them?
No, but I do tell them, humor me. Go fill out it, even if you're 100% clear, 100% sure, and names your spouse as a primary and your kids as a contingent. I said, just do a new beneficiary designation form with what you want, sign it, and send it in. And most companies will give you a confirmation letter. Oh, we received your beneficiary designation. Here are the people you've got down.
Yeah. And that confirmation letter should go right inside your estate planning book.
With all your other documents, so that whoever, if you both, husband and wife both passed away, who's ever acting as successor trustee, they realize, hey, mom and dad have an IRA here. Here are the beneficiaries.
Yeah. The other thing about during a lifetime is the QCD. You have it number 5 here on your outline. Talk a little bit about that, because it's now permanent law, and
Yes.
before it went in and out. But why should every single person who's 70 and a half know about this?
So the QCD is a way for you to take a distribution from your retirement account, and instead of getting it, directing it to your charity of choice. And where this makes a lot of sense is there are individuals who are required to take a distribution from their IRA, but they don't need that money. They've got other assets, but they're also charitably inclined, and they already give to money to charities already. So why not direct the required minimum distribution amount to go directly to the charity? You don't pay income tax because the money didn't come to you, but you don't get a charitable income tax deduction either. But what you have done is that you can make your, you fulfill your charitable goal of, I wanted to give something to charity anyway. And also then I've met my RMD requirement that year, because I've said, oh, I don't need the RMD, go to charity of choice.
Yeah, because most of us are not doing an itemized return. And so today we're not getting any income tax benefit from making a donation for the vast majority of us. But on the QCD, so long as you make it payable to the charity, the check, and recommend highly, a lot of times these charities receive a check from an institution, but they don't include your name on it. They just all of a sudden get a check and they don't know where it came from. So if you want to make sure that they know who you are, one of the things that Don has recommended in the past, have the checks that are made payable to the charity be sent to you personally, and then you can mail them out to the charitable organizations. Is that correct, Don?
But before you mail it to them, make a copy of it.
Make a copy.
Because whoever's managing your account will give you a 1099-R, I believe, that says, here's how much the total RMD payout was. They may or may not give you a statement that said, and here are all the charity, and you can have 1 charity, 10 charities, whatever you want. My wife and I go through and go, okay, here are all the charities we want to pay. And that's what we choose to do. For exactly to Pete's point, if we're going to give the money away anyway, let's do it this way, because it is not a tax deduction. It is a tax of, it doesn't come into your taxes. So even if you, I was going to say, not avoidance, not evasion, even if you're taking a standard deduction, this allows you to reduce your income because it's taken right off the top. It never becomes income to you. So if you had, $20,000 coming in, so the 80-year-old we were talking about earlier, if you have $20,000 that's coming in, that's going to be taxed to you exactly like the normal, ordinary income. But if you then want to turn around and give $20,000 to charity, that probably cost you $5,000. Because when you brought it in originally, you paid tax, and in fact, you paid tax on the tax when you brought that money out. And so this completely saves all that money for you because it never got into your income. And that's really important, because when it gets into your income, you pay tax. You may pay a higher tax because you have more income. You may also pay more on Medicare because your income's gone up. And incidentally, your Social Security will be taxed higher as your income goes up. So you just got hammered on all these things, but you gave the money away. So there really is no reason to do that. Use a QCD. I admit you're only limited to $100,000. Gee, that's bad. A year, okay. That doesn't affect me, but that's what you're allowed to do. Tim, do you want to talk about giving it to a charitable gift annuity, or do you want me to?
You're doing
I'm
great.
on a roll. Go ahead and do it now. Okay.
This is something, again, I know enough to be dangerous, but I don't deal with these things more than financial advisors do. So,
Donna's our philanthropic advisor, so he's going to be doing our charitable opportunities.
And I'm not, Tim and I talked about this before, since I deal with them daily. Anyway, so an option now that they've come up with is if you are over 70 and a half, you can do these things. It's really, to me, more when you start paying an RMD over 73 years old, that you start doing this. Now you are allowed to give $50,000 to a nonprofit and establish either a charitable gift annuity or a charitable remainder trust. I'll be honest and tell you the charitable remainder, a CRT, isn't worth it. No. It's going to cost you more money to administer for a $50,000 CRT than anything. However, charitable gift annuity, my friend, the 80-year-old, will earn 7.6% on that before taxes and have that as income for the rest of their life. After tax, that's about 11% they're going to earn, because most of that money is going to be tax exempt. So it's a wonderful way to give money. Charities are very happy now about it because you can do it. You are not allowed to do your charitable gift annuity into a donor advised fund. Can you do a QCD with a qualified plan? No, you can't. This is out of an IRA. And incidentally, an RMD is only from an IRA. It is not from a qualified plan. So that's one of the things we talked about. Should I transfer my 401k into an IRA? If you transfer it at an older age, you have a required minimum distribution. In a qualified plan, you do not have a RMD, I don't believe.
Sure about that, Don.
Because okay.
I'm not so sure. I thought you had to take distributions if you still have a 401k. You're no longer working. You have
that may be.
You have to take your required minimum distribution, no matter what kind of retirement plan it is,
except Roth.
Except Roth,
right? Yeah. And you might be right, because it's pre-tax dollars. And so that was a question that just came in. And I'm going to say I don't know. My understanding it was IRAs, but I could be wrong. Absolutely.
But and we're going to be talking more about this in the charitable opportunity session, but just remember the QCD on your IRA is a great way to go. One other thing, Tim, which I see a lot of, and that is people name the charitable organization in their trust and leave the IRA to the kids if they have a charitable intent.
Right.
What are they doing and why?
So it's very common, you tell your attorney, hey, I want to give $10,000 or X amount to charity when I die, and you put it in your estate planning documents. So then, okay, the trustee's administering the assets and makes the charitable donation. That's all well and good. But I usually tell people, hey, it makes a lot more sense that if you do have an IRA, that why don't you make your charitable gift in the IRA? Because the charity doesn't pay tax. Whoever pulls the money out of the, if it's me, the beneficiary, I've got to pay tax. It doesn't matter if I put the money in and I pull the money out, or if I die and my kids now are the beneficiaries of the IRA, they're going to pay the tax. But if I name the charity as the beneficiary, the charity gets every dollar for dollar out of that IRA, no tax. So it's a lot easier to, it's a lot better for the charity by giving them more bang for their buck, by giving them an IRA asset, as opposed to leaving your kids the assets from your trust that probably are no taxability from, not subject to any income tax from the trust assets, versus leaving your kids assets that are IRA assets that they're going to have an income tax liability when they pull the money out.
So I use as the example, for instance, when we do the charitable session, that if you had two assets, I have an IRA at $1.5 million and I have a house at $1 million. The kids are going to say, we want the IRA because it's $1.5 million, and we'll give the $1 million house to charity. Here's the problem: if the kids get $1.5 million out, they're going to pay max federal income tax. They're going to pay max state tax, And the net that they're going to get is probably about $745,000. It's over half goes to taxes. The charity got the $1 million. If you reverse it, the charity gets $1.5 million and they love you dearly because you gave them the $1.5 million. The house at your death, step up basis, the kids sell the house and cash it out for $1 million. But it doesn't sound that way when you start, but it is because of what these are.
Don't you love having a CPA as part of the panel? It's so true, though. You know, people don't run the numbers to see what the after-tax effect is. And that gets you to point number 6 here on the outline. What is IRD?
IRD is income in respect of a decedent. It's, you know, your IRA, it was your IRA, you've passed away, you've named your 3 kids as the beneficiaries of this IRA. So when they have to take their distribution from that IRA, that is income in respect of a decedent.
So if they, let's say you have $300,000 in your IRA account, they have earned in the year that you died $100,000, they withdraw the $300,000. What are they paying the tax on?
Whatever they made their $100,000 salary plus another $300,000 of whatever the IRA was.
And that $300,000 would be IRD.
Yes.
So because if the beneficiary had taken it out, they would have had to pay the tax.
Exactly. Someone's going to pay the tax on the money in the IRA. If it's not the owner of the IRA because they passed away, the beneficiaries of the IRA are going to pay that tax.
And it doesn't matter whether it's a 401k, a 403b, an IRA, SEP IRA, 457, etc.
Correct.
And just as a note, when I made the comment that if you take the money in from the required minimum distribution, your income tax goes up and possibly your Social Security and possibly your Medicare expenses. That's for the year in which you took the money. Now, the following year, if you have lower income or something else, the rate will drop back down again. But you're also taking your RMD again next year. And generally, they actually lag back 2 years. Yeah. So if you took the money out in 2023, it probably will not affect you in 24, but it may well affect you in 25 by the time they get around to looking at your tax return and actually going, ooh, let's charge more money on this. So that does vary based on your income. It isn't a permanent up or down. It changes.
Yeah. Let's go to the many options for distributions from an IRA and a qualified plan at death. Number 8.
So with
good. I've skipped number 7, but talk a little bit about 7 because for most people, they're not going to be concerned with this.
Yeah. So people wonder, you know, so we talked about the tax considerations of, okay, I've passed away. The IRA is now going to my kids, the beneficiaries. Then, you know, there's going to be income tax when they pull that money out. Well, so here the top income tax rate, 37%, but you need to be earning more than $500,000 a year for that. Married couples, almost $700,000 before that top income tax rate. Estate taxes, completely separate. It's just based on all assets you own. So it would be your $1 million house, your $1 million bank account, your $1 million IRA. That's all includable as tax in your taxable estate. However, each person has the ability to transfer up to $12,920,000 in 2023. That's the estate tax exemption. So if your total estate is less than that amount, or double it, so your total estate is less than $25 million plus for husband and wife, then no estate taxes. So you need to have more than $25 million in today's world before worrying about estate taxes. And yes, estate tax laws are always subject to change. There are current law of this $10 million per person index for inflation, estate tax exemption. And with the current index for inflation, that's why we're at $12.92 million. That's good for this year. It's good for next year. But December 31st, 2025, this law terminates, and the prior law is effective of a $5 million exemption per person index for inflation. So Congress could sit on their hands and does nothing, and then January 1, 2026, instead of being an estate tax exemption of $10 million, it's $5 million per person.
You know,
or maybe at the 11th hour, Congress will act and do something to extend this current estate tax laws for another 4 or 6 years, and then they, let someone else deal with it type thing.
Did you ever imagine that in 2010 there would be no estate tax for a year?
I remember as literally 3 years out of law school, and there was a big tax law change in 2001 that George W. Bush handled, and it was increasing the estate tax exemption from 600,000 to 625 to 650 to 675 to $1 million to $1.5 million to $2 million. And there was a year, and part of this, that there was no estate taxes in 2010. And everyone, I remember going to this conference like, oh, well, no problem. Congress will definitely do something before that happens, and they will never allow it to go no estate taxes. And then what happens, lo and behold, we get to 2020 and there was still no estate tax that year. So Congress didn't do anything till the end of 2010.
Yeah. So anybody tells you that they know what's going to happen in 2025, don't listen to them.
Nobody knows.
Nobody knows.
It's one of those things where I have clients where we're trying to do some planning now, and we're going to wait and see. And hopefully something will happen, but as Congress typically asks, they probably won't do anything until after their summer break. So it will be September, October of 2025, where they'll finally take on this issue and then deal with it.
Yeah.
But who knows? Like, I think that was the plan probably in 2009 that they were going to do this, but that was the exact same time that Hurricane Katrina ruined Louisiana. So they didn't do anything because they had other things to worry about.
Yeah.
So the same thing could happen. There'll be some sort of, national emergency that occurs. And so then this is an estate tax issue, and they shrug their shoulders to it and they worry about it later.
Yeah. Well, whenever you see a sunset provision on a bill, it means that they didn't have to have corresponding tax issues of revenue. And so that's why you see a sunset bill. So we'll see what happens. But let's go to the options for distribution from an IRA and a qualified plan. What are these options?
So it really depends on, there's my depends. It's even in my outline depends. For the most part, the companies that I've dealt with, or the companies I've worked at, when you're no longer an employee there, they basically want you to get your money out. They don't want to deal with you any longer. They start charging you like a quarterly fee to have your IRA or your 401k there. So for the most part, companies don't want non-employees input part of their qualified plan. But if you are part of it, then it's an issue of what does the company say? And sometimes companies are pretty flexible, and other times I've seen companies that are completely unflexible. I mean, I had a client once, I believe it was Johnson & Johnson, and the individual passed away, and the only beneficiary, and it wasn't a 401k, but it was some other employee perk that he had, the only person you could make as a beneficiary was a spouse. There was no option to do anything else but a spouse. This guy had no spouse. It was subject to probate.
Yeah.
It was crazy. It was absolutely crazy. I'm like, what? And he was in human resources too. And I was like, this is your job, and you don't allow for anything else? Like, oh, that's what the attorneys did to administer the plan. They only said you only need a spouse. And I'm just like, crazy.
Okay. So we have a traditional IRA, and we have husband and wife. And so one of the options is naming the spouse.
And that spouse has the most options. So from an IRA, the spouse can decide, okay, I'm going to take my spouse's IRA and roll it all over into an IRA in my own name.
So they can do that.
And I can wait till then I'm 73 and a half or 73 before I have to take any minimum distributions.
Okay. And then what if the surviving spouse remarries? What happens to, let's say I'm married to the gal, I die, she continues to live and marries another person, and they have kids. Can she now leave that IRA to the other kids?
Yes, because it's her IRA, because it was rolled over from the beneficiary was the surviving spouse. Surviving spouse now has total control over what that IRA, who the new beneficiaries of that IRA are. So
upon a divorce or whomever you've name, if you leave your old spouse's name on as a beneficiary on an account, does the new wife of 30 years, for example, receive that IRA?
Nope. I have literally had situations where someone passed away, been married to someone for 25 years, for whatever reason, forgot to update the IRA beneficiary. Spouse for marriage number one was the primary beneficiary. My client, surviving spouse, there's nothing that she can do about it. The beneficiary designation controls. Just because you get divorced, just because you get remarried, it doesn't mean those beneficiary designation forms are invalid. You have to keep them updated.
Okay, how about a contingent beneficiary? What does that mean? And should people put contingent beneficiaries on the form?
So the contingent beneficiary is if the primary beneficiary is no longer here, they've predeceased the owner of the IRA, then we look to the contingent beneficiaries. So typically, if people are married, they've got kids, primary beneficiary, spouse, contingent beneficiary, children. So if mom and dad pass away in a common accident, it's very clear. Kids get the money. Or if mom passes away and mom doesn't, or if dad passes away and mom doesn't do anything to the IRA and she passes away shortly thereafter, kids are still named as beneficiaries. They would still get the assets.
Should I name kids that are under the age of 18 on my IRA account?
So here's the big depends on who are the proper beneficiaries on an IRA. And I tell clients in my mind, there are two factors that I think about when I recommend beneficiaries. Number one, size of IRA, and number two, financial maturity of kids, or if they're, adults or minors. So
what is considered an adult as far as an IRA is concerned?
18. 18 is the age of majority in California.
And what does that mean if a kid 16 receives an IRA?
And I've had situations where minor children were named as beneficiaries of IRAs. And typically what the financial institution wants is some sort of court-appointed guardian to manage that IRA for the benefit of the child until the child reaches age 18.
So at 18, the court considers the individual to be a mature adult and has ownership.
Correct.
And they could do whatever they want then at the age of 18.
Correct.
Okay. So how would you recommend kids getting the bulk of their IRA account at the age of 18?
If the IRA might be $1,000, that would be okay. But other than that, it's usually not a good idea to have, any teen, obviously no one under the age of 18. If you have beneficiaries under the age of 18, you need to name your living trust as the contingent beneficiary on your IRA. And you need to make sure you've got provisions in your living trust that take into account of what to do with IRAs and qualified plans.
Yeah, we'll talk about that in just a little bit.
Yes, but
go ahead and so you got a contingent beneficiaries, not to leave it to kids maybe under the age of 18. What about the other kids?
I've got a 25-year-old kid who's just financially immature. I could name that kid as a beneficiary, but I just don't want to, just because I don't think that kid will do the right thing and manage the money appropriately. So in those situations, I'd say yes, put down your family trust, your revocable trust as the contingent beneficiary, because then hopefully the trustee would manage that money appropriately for the benefit of the beneficiaries.
So in trust administration, someone dies. What's the first money that becomes available to the beneficiaries?
If in a trust administration, what typically happens is that, yes, the clients have done a good job putting their house and bank accounts in the name of the trust, but what they haven't done is they haven't updated the beneficiaries on her retirement accounts. And in those, usually the kids are the beneficiaries. So that's the mad money that the kids can have. They can immediately, so long as they're over the age of 18, they can call up the financial institution, say, hey, I want my money. I want my 1/3 share or my 1/2 share, or whatever. There's 3 kids, everyone gets a third. The kid can say, give me my 1/3. There's $300,000 in the IRA. I want my $100,000 right away.
Yeah.
And
so they have to go down to go to the institution or the bank or the brokerage firm, hand them a death certificate and a driver's license, and they have the beneficiary designation form, and they'll write them a check.
Yep.
So since we're
but they also get a check, but they also get a tax bill for here's the $100,000 of income that you just earned by taking the withdrawal.
But when do they get that tax bill?
they would get the tax bill when in the beginning of the year, when you get all your other 1099s,
Yeah.
W-2s, and everything else,
The following
of January, the following year.
Yeah, the following year. And when the money
to that point, so a friend of ours, her mother passed away, her father was the beneficiary. He gets the money, and he's probably in his 60s or 70s at that point. He goes out and buys a Porsche because she wouldn't let him buy a Porsche while she was alive. So he cashes out her IRA to buy the Porsche, and then the beginning of the next year gets the tax report on it and can't afford to pay the taxes. So it isn't just young people, it's also crazy older people at times too.
People forget about the IRD, and the person at the Schwab or Fidelity or Vanguard doesn't counsel the individuals to say, you're going to have to pay tax on the amount of monies that you withdraw. I'm going to ask you a question. When you help individuals do their trust administration, do they come to you first and say, gosh, please tell me the tax ramifications of taking money out of the IRA account?
They usually have already done it before they even contact me.
Yeah.
I usually get a call maybe 2 or 3 months after someone's passed away. They're like, okay, we got to sell the house, get stuff organized. I can't access mom and dad's accounts in the name of the trust. Help me become the trustee or get the tax ID number so I can go to the bank with the proper paperwork. But they've already blown through the IRA money. It's gone.
Yeah, and this is so common. And what happens is with parents, they're taking out the required minimum distribution, and because they're worried about having to pay the tax. And here, all of a sudden, their kids are at the top tax bracket, and they're taking out a lump sum. It's crazy. So, sit down with the kids, talk about IRD. And talk about the tax aspect. It might be better for you to take it out of your IRA account at your tax rate and then give it to the kids. There's options.
There's options, and this is something that I would work closely with a CPA taxpayer to kind of run the numbers here and see what makes most sense.
Yeah. A beneficiary. What is their options as to, can they keep it in the IRA? Normally we had a term called the stretch. Talk a little bit about the stretch and how that has changed today.
So prior to the Secure Act and Secure Act 2.0, there was a lot of flexibility that if beneficiaries were highly financially motivated and engaged and were very they're very smart, they say, okay, mom and dad's passed away, now I can not take all the money out. I don't want to pay the taxes. I want to set up an inherited IRA. And so then the money goes from mom's IRA to this kid's inherited IRA, and now the kid takes minimum distribution over the kid's lifetime. And the kid's much, much younger than mom. So that divisor amount they need to pull out is very, very small. And so that money can continue to exist for a very long period of time. And I had a few clients that really did the right thing. And they were able to sock all of that money away. The retirement of funds that mom and dad had, they were able to sock it away. And that was supplemental retirement that they could use because they only took a small amount, the minimum amount every year.
Yeah.
Unfortunately, nowadays, the rules have changed. 10 years. That's it. You
Today,
can still do a rollover IRA, but it's all going to come out in 10 years.
10 years. And do you have to take it out in any 1 year, or?
You could take it all out in year 9. You can take it all out. You could take 1/10 every year for 10 years. You can do whatever you want. It's just got to come out in 10 years.
So as somebody who's going to be a beneficiary from an IRA really should sit down with their financial advisor and a CPA and say, we got 10 years that we can do some planning as to when to take out that income to give us the lowest income tax bracket.
Yeah, if there was a year where the child lost a job and didn't have a lot of income, hey, take out some more money that year because that will be kind of replacing the income that you didn't make. Yeah. Versus the child had a fantastic year and a huge bonus, and they're in a top tax bracket. I wouldn't want to take out money that year because you're only going to pay more tax on it.
Yeah.
And incidentally, if mom or dad or whoever you're inheriting it from who are over 73. During the 10 years, you're required to take a required minimum distribution. Once they've started taking it, then the account will have to have it going forward. It's not going to be a large number because of the age of the child, but at the same time, that has to be done.
Yeah. And that's number 10 point, right? What are the rules post-death on the IRA? And the Roth IRA is similar, but you don't have to pay any tax.
Exactly. You still got to pull it out. You just have to pay tax on it, but it's
Yeah.
still no longer going to be protected in this tax-free shell of a Roth IRA.
Yeah. And qualified plans, 401k, 403bs, I don't believe they have that feature unless the employer puts it in the plan.
Yes.
I would say 90% don't.
I would even say 99% don't, because it's just too much administration and they don't want to deal with it.
Yeah.
Too expensive.
And it's another great idea to do the rollover to a Schwab, a Vanguard, or Fidelity. Here's some of the exceptions.
These are the exceptions to the post-death rules about the 10-year rule.
By the way, can you do any planning post-death? In other words, you name a spouse and you got some contingent beneficiaries. I've heard that attorneys sometimes work out that the primary beneficiary can disclaim their interest. When would they do something like that?
So when someone passes away, you can a qualified disclaimer, which must be done within 9 months at someone's death. And by saying you disclaim it as if you predeceased the person. So it does no longer go to you. It would go to, if the document says, I want the money to go to my beneficiary, my son, my daughter. But if my son, my daughter predeceases me, then it goes to my son, daughter's kids. So if I'm that son and say, I disclaim my interest, then that's as if I predeceased, and now the money goes directly to my kids.
So you could do some planning.
There's some options.
Yeah.
But for the most part, it's surviving spouse doesn't have to adhere by the 10-year rule, because we talked about they can roll it over into an IRA in their own name.
The exceptions to that 10-year rule.
Exactly. Or, minor children or someone who's ill, something like that. So there are some exceptions, or the biggest exception again is surviving spouse. But I should say I had recently a surviving spouse. The bulk of the funds were in husband's IRA. He passed away. Surviving spouse took that huge IRA account and split it into two. One IRA in her own name so that she didn't have to take distributions until she was 73. And the other IRA, she did put into a inherited IRA because she was under the age of 60. And so she thought, gosh, all this money is in the IRA. If I ever need it, I'm going to have to take a penalty if I took it out. So this way I'm going to hedge my butt. I'm going to put some money in an inherited IRA that I can access without penalty over the next 10 years. But the bulk of the funds went into the spousal IRA rollover that she didn't have to take until she was 59 and a half and then must take at 73.
Yeah,
so that was a great tool for the spouse to basically I had access to this account that I otherwise wouldn't have because I'm not 59 and a half just yet. Because if I access it before 59 and a half, I have that onerous penalty.
Yeah, if you have some wealth in an IRA account, 300,000 plus, you need some help from experts. And
yes.
Whether it's a CPA, whether it's a fee-only advisor, a tax attorney, or somebody who's involved, such as Tim in this area, no one person has all the answers. And Tim has been in the area for 30 plus years, and he doesn't have all the answers because the laws always continually to change. And you're not just in the estate planning area, but you're in the tax area. So it gets a little bit different. Designated beneficiaries, that's another term of art.
So the designated beneficiaries are just basically who the beneficiaries on that IRA or qualified plan, the primary beneficiary, contingent beneficiary. And every financial institution will have its own beneficiary designation form, and they're all a little bit different, and they all say essentially the same thing, but they just, everyone, they got their own terminology.
Can you put in, the form that they give you is a really small space. And so let's say, hey, I want to give 10,000. Can you do a specific amount, or does it have to be percentages?
Unfortunately, here's what it depends. Whatever the financial institution allows.
Whatever.
I've seen some forms that say amount or percentage, but
Can
more
you-
often than not, I would say 75% of the time, it's the financial institution wants a percentage because they want to make it easy on themselves.
Yeah.
It's 3 beneficiaries, a third, or it's 4 beneficiaries, 10, 10, 10, 60, whatever.
You can put on there on the form C attached, and then attach a paper explaining how you want it distributed. The key is make sure that the financial institution will honor that.
Yes. I mean, I have seen some financial institution as, they have this form on file, but it's a 3-page beneficiary designation document. And when someone passes away, the financial institution says, try again. We're not doing this.
Yeah.
We want something straightforward and simple. They want someone who's just behind some desk somewhere and just to be able to cut 3 checks. They don't want to read some document and interpret, oh, the money goes to this person if they're not alive, and it's this amount, or it's X amount per month for the next 2 years, or whatever. It's like, nope. So if you have something special, make sure the financial institution will honor it before you offer it.
Yeah.
Usually it's whatever it's on their form is what they want. The C attached letter is not going to work out.
And make sure the designated beneficiaries are younger than you.
Yes.
And because if they're deceased, then it goes to their heirs, and then likely it might end up in probate. So, so we talked about, I'm going to talk a little about number 12. In what scenarios should you use a revocable trust as a beneficiary?
So again, we hit on this very briefly. Minor children, financially immature children. We don't want to name them as beneficiaries on the retirement account, so we have to name the trust. But again, we want to make sure the provisions in the trust that talk to about, here, what happens when the trust is a beneficiary on a retirement account? There's got to be some special verbiage in the trust. It's not, oh, we've got the trust on LegalZoom. That's going to work. Absolutely not. The LegalZoom trust is not equipped to be a beneficiary on a retirement account.
What if you would name a living trust and the money is transferred into the trust, and the trust makes no distributions in the tax year of when they received that monies?
So you've got the trust as the beneficiary, the trustee of the trust pulled all the money out of the IRA. Well, now the trust is going to have a big income tax bill to pay that year. And if the trust doesn't distribute some of that income to beneficiaries, well, then that's a trust income tax responsibility, not a beneficiary income tax responsibility.
And
so the trustee has to be savvy about what they're going to do when they're dealing with this. If the trust is the beneficiary of an IRA, the trustee really needs to know what they're going to do, what their options are, what they can do for the beneficiaries. Because the last thing they want to do is pull all the money out and pay a big income tax bill.
Are the trust income tax brackets exactly the same as the individual tax brackets?
Unfortunately, no. The trust income tax, the highest rate, 37%, is after about $15,000 of income. The trust pays that tax bracket. So typically when there's a trust and there's income being generated, the income goes to the beneficiaries, so the beneficiary gets the income tax bill. But if the trust doesn't distribute any money, then the trust pays income taxes at a much higher rate because it's everything over $15,000 of income, 37%.
So when a trust is a beneficiary of an IRA account, it's usually a subtrust.
Yes.
Do you charge extra designing a subtrust for an IRA account?
I do not. I mean, honestly, it's an extra couple of pages in my document. I just put it in everyone's document, even in clients that have, $50,000 in IRA and they have financially mature adult children. I still put it in there just because you never know what happens. So, and there are attorneys also, and I have seen attorneys charge for IRA trusts. So it's like a separate standalone trust that would be the beneficiary of the IRA, and they charge $5,000 or $7,000 for these things. And it's like, maybe there's some extra help that comes along with those that my 2 extra pages of my living trust document doesn't. But in my mind, I don't think it's, I mean, again, maybe it's a $10 million IRA. Okay, well, $5,000 for an IRA trust might make sense. But I just don't have those, uber wealthy clients where we need to set up IRA trusts and everything else. I just think the extra 2 or 3 pages in my living trust document achieves the goal, especially when all the money's got to come out in 10 years now. There's no more stretch IRA provisions.
Right. And then the can a trust be an owner of an IRA?
Absolutely not. If someone said put the IRA in the trust, I guess the IRA company would say, okay, that's a distribution of all the assets to the IRA owner, penalty, income tax, and now you can have a trust account. So you have to have the IRAs in individual's name, no other option.
And if you have a special needs, whether it's bankruptcy, spendthrift, government benefits, you go through what's called a conduit or accumulation trust. We're not going to get into it because those are very complex.
I mean, the bottom line is those are the two in my living trust document. I have provisions that talk about either a conduit trust or accumulation trust.
Yeah, and every financial institution won't have a clue to what the trustee is talking about.
It is, yes, next level of complexity.
Yeah, complexity, yeah.
The bottom line is it's the accumulation trust that I usually offer to my clients. The conduit trust just says, okay, the trustee is now taking out that amount, and then they must turn it around and give it to the beneficiary.
Yeah, what I usually advise individuals is that leave the bad money, and I call the IRA money the bad money because it's going to be taxable. Leave that to competent children, adults.
If they're available, yes.
If they're available. Allow the trust, use the charity as the a potential. You can name a charitable trust as the beneficiary, and the charitable trust then gives it to your children. That's also another tool that you can use.
But the bottom line is the conduit trust is just the trustee is maintaining it and making sure money comes out however the trustee believes, but the trustee doesn't have any discretion. Once the money comes out, it must go to the beneficiary. And the accumulation trust, you have the option of, oh yes, the trustee is managing it, but then the trustee isn't forced to give the money to the beneficiary as soon as it comes out of the IRA. It can be held in the trust. And yes, there might be income tax consequences to do that, but if you have a spendthrift beneficiary, it still might be the best thing to do.
Let's scroll down a little bit. And we've got 5 minutes left, and talk about just the common mistakes, and then we'll end the session.
Yeah, so the bottom, and we've touched on many of these already in our discussion, but the biggest problems I see when it comes to an IRA and someone's passed away, number one is obviously they didn't have any beneficiary designations, or it was I can't remember Wachovia Bank, which became Chase or something. I remember some guy, when that happened, Chase didn't keep any records from Wachovia, and
I used to work for Wachovia Bank.
Yeah, $500,000 in an IRA, no beneficiary designation at Chase, therefore probate. Even though the guy walked in with the Wachovia beneficiary designation form. Tough luck. It wasn't the Chase form, therefore they
Number B, letter B. Always, I see this so often.
Someone has, they have got 2 kids, and then they do their beneficiaries, and maybe 5 years later they have a 3rd kid, and then they pass away, and there's only 2 kids beneficiaries, not all 3. Happens all the time. Or the divorce and not updating them because of a new spouse.
And you can't change it. Whatever's on that form,
you're stuck. You're stuck.
I just had a case. They said my estate as a beneficiary.
I mean, again, you just cause a probate. Yeah. What does that mean? I mean, why would you do that? I don't understand. Why didn't anyone counsel the person no, that's not what you need to do. Name an engineer, name a charity, name a trust.
It was an engineer who wanted to do his own estate plan. and he put my estate, and it took 2 years for his girlfriend to get the monies. Not naming a beneficiary is a minor or financially immature.
Yes. Yeah. So if I've had, again, just recently, a bunch of kids, young kids, ages like 3, 4, 5, were the beneficiaries on an IRA because parents had recently divorced. He updated his documents to say that his kids are the beneficiaries. He passed away very unexpectedly. And now I had to go to court to get guardians nominated in order to handle the inherited IRAs for these 3 kids.
Yeah. Lots of money.
Lots of money,
Over a lot
I mean,
of
it wasn't
years.
even a big IRA too. And I spent more in attorney's fees than was the IRA. It was ridiculous.
Yeah, it's almost like you hate it to do it, but you got to charge.
Like, what can I do? It was still worth it. It was just painful.
Yeah,
Tim,
not considering
Tim.
the tax issues.
Tim, scroll up to the very top of your document so we get your name back on it.
Oh,
There you go. Thank you.
there's my name.
Just I'm trying to do marketing for you.
Okay, thanks. Let me go back down to the end.
No, we
The
got
last couple items of
We got
not
it.
keeping records of beneficiaries,
Right.
of don't rely on what, oh, I've got it done, I've sent in the form, whatever. Make a copy of the form or get some sort of confirmation from the financial institution and put it in your estate planning binder with everything else so you know it's done properly.
Right.
Don't rely on the company to handle it. They lose stuff all the time.
All the time. All right, let's why don't you stop sharing your screen and we'll come online. Great job, Tim. And you only
Yes.
use depends about 3 times, which
I
is
know, I tried.
an absolute-
I was really catching
actually
myself.
it was 8 times. I actually was
but
picking
that's
it up.
record. That's a
That is a
record.
record for a lawyer for this long. For an hour and a half of talking and only using depends 8 times.
Thank you very much, Don. Appreciate
That's
it.
okay.
Do we have any questions,
No.
Don?
We've handled them along the way. So
Perfect.
thank you very much. It's financial and estate literacy. This has been It's Your Estate on Retirement Planning. Next week, as we have said, there will be no session, so you won't get a reminder that tells you there isn't anything there. The week after that, we will do charitable giving, and I think I'm doing that session. And so we thank you very much, Tim. It's been fun. Pete,
Thank you very much. Appreciate it, Pete. Appreciate it, Don.
entertaining as always. So thank you very much. We have a good time.